that proposition?
There are a number of cases that have come and applied this exact theory, that when there is a silent record, the presumption of reasonableness bars relief for the petitioner. Burt versus Titlow is the Supreme Court's case in 2013, where the court said it should go without saying that an empty record cannot overcome the presumption of reasonableness. Williams and Jones and Broadnecks are cases that the state cites which also apply in both state and federal courts, the 11th Circuit as well as state courts in Alabama and Texas, that when you have a silent record, the presumption of reasonableness cannot be overcome. The Supreme Court's pronouncement is not that tilts in favor of the state. It is that if you have a silent record, because the presumption accords reasonableness to the decision not to investigate a particular avenue, that a petitioner cannot obtain relief. Judge Grafe, in her dissent, explains that it would be difficult to overcome it when the counsel does not testify. The reason she says it's difficult is because there are other ways, of course, to supplement and complete the record as to the reason. In Cullen versus Pinholster, for example, there's a disagreement between Justice Sotomayor in dissent and the Supreme Court's majority as to whether or not you should look at the reason that the counsel gave on the record. The counsel gave a reason on the record, which Justice Sotomayor thought controlled. The majority ultimately concluded that even in the face of that, they were directing both lower courts as well as the Supreme Court's decision in that case that you were required to entertain the spectrum of possible reasons even when counsel gave a particular reason. So under the Cullen tradition, even if there is a reason that is provided on the record by counsel, courts are now required since 2011 to entertain possible reasons that could justify it. But Burke versus Titlow, a more recent Supreme Court case, says that on a silent record, the presumption of reasonableness requires that the relief cannot be obtained.
When counsel, is it reasonable to suppose that in making her decision, counsel would not even contact or speak with this alibi witness?
So there is no dispute that Ms. McClain, the record is clear, was not contacted. So on that, the record is clear. We do not dispute that.
No dispute about that.
That's right, Your Honor. There is no evidence that there was contact. There is evidence, of course, just to flag this, that Ms. Gutierrez nonetheless had some sense of the gist of the alibi, the time, the location, what she would have said, as Judge Grafe points out in her dissent, 2:15 to 3:15 was in the note from July 13th, 1999, several months before the trial.
And it was the time that the state was suggesting this murder occurred.
That is right. There was a witness that the state presented and suggested that that would have been the appropriate time. This was a subject of great dispute. The evidence on this, respectfully, was weak, but it was the proffered theory that the state presented. To your question, however, about what we do when the reasons that are possible, the state has identified a number of them. The most obvious one is that the alibi that was proposed by Ms. McClain was inconsistent with what Mr. Syed had told not just defense counsel privately, but publicly what he had told police. He had identified what he remembered where he was, that he was at the school, that he was then at track practice, and then he was at the mosque. And on a number of occasions, in every instance, as soon after he was arrested, in late memoranda, months before the trial, even after the first trial and before the second one, he never, not once, indicates that he'd ever been to the public library on that day or any other. In fact, there's record evidence that the school library was the library he used when he wanted to check his email. There were two witnesses who had told detectives.
Am I correct in remembering that the other library, the one the alibi would have talked about, presumably, was right across the street from the school?
It is in close proximity to the school. But be clear, Ms. Gutierrez appears to have been aware of the proximity. In the list of tasks that she identifies, she actually separately distinguishes a map of the Woodlawn Public Library versus the map of Woodlawn High School. So she seems to be aware that they are in close proximity, but that they are separate. But this is not one of those circumstances where it could have been confused. On the in the first instance, it should be emphasized that multiple witnesses specified that Mr. Syed did in fact check his email at the school library. That's the first piece of evidence, I think, in the State's favor. The second one is, if there is a question about whether or not this is incompatible, this is not Syed saying that he was in Bermuda and a witness saying, no, he was in Maryland. There is some nuance between this. The State acknowledges that. But those are exactly the kinds of judgments that defense counsel have to make.
But should defense counsel make it without even talking on the telephone with this witness?
You know,
That's the question.
It's a fair question, Judge Atkins. When you present a proposed line of investigation in its singular form, it is hard for the State to say, oh my God, that would have been so onerous. But what respondent seeks here is a per se rule that whenever a possible alibi witness comes forward, you are required to contact them. That's why they believe they can overcome this silent record, because it is always required. And that would be an extraordinary and onerous obligation.
Well, do they say that it is always required, or that it is required when it is the alibi is given to the attorney within a reasonable time before trial, so that the attorney would have a chance?
It is certainly the case that you can add certain conditions to why the per se rule will be triggered. So, for instance, if it's sufficiently ahead of time and the information is provided to defense counsel,
and a phone number,
and it appears relevant, and you have a phone number, in that case, we believe, I think the respondent would argue, that the per se rule is required. I think the challenge with that is contrary to the way that the Supreme Court and this Court has fashioned Strickland jurisprudence. In fact, Strickland itself said we shouldn't articulate mechanical rules because that will confine the latitude that counsel need to do their job. So whether you add conditions or not actually complicates the task, because in future instances, defense counsel will have to say, well, is this far enough along beforehand that I'm obligated to do this, or can I exercise my judgment that I don't want to put him at the public library because he told me he was at the school. I don't want to put him at the public library because that could raise a risk with the general alibi by routine that I intend to present. All of those things are the kinds of judgments that I think counsel is allowed to make, even when it's easy.
Well, Mr. Vignarajah, wouldn't you accept that there is a distinction between a failure to conduct even minimal investigation and a situation, not this one, where there is an investigation, but in the end, counsel makes the judgment that we accord to counsel, the discretion as captain of the ship, as it were, to say this will be more harm, do us more harm than good? We don't have anything close to that here.
Well, I want to make sure we distinguish between the Kimmelman scenario and the scenario that Strickland contemplates. Strickland says counsel have to make decisions to investigate or make a decision that a particular investigation is not necessary. Now, so Strickland itself contemplates not doing any particular investigation because the counsel has reasonably declared that that is unnecessary altogether. Kimmelman, however, set up a different scenario where counsel didn't do any investigation on any score. Strickland talks about the possibility that great lawyers will pursue a particular case in different ways. There may be 7 different lines of investigation. One great lawyer will pursue 5 of them and ignore 2. Another great lawyer will pursue a different 5 of them and ignore the first 2. Kimmelman suggests that it would be constitutional error if an attorney didn't pursue any of them. In that case, of course, when they talked about the requirement of pursuing some investigation, this is an attorney who didn't obtain discovery because he believed that the state's obligation was to hand over discovery. That Kimmelman scenario is certainly not what we have here, Your Honor.
What do you make of Griffin versus Warden, a case upon which your sister counsel relies on in this case? We seem to suggest a contrary outcome than the one you propose here.
Well, I think there's a number of reasons why Griffin is quite different. First of all, Griffin was a case where counsel actually gave the reason for why he did not pursue this particular investigation. He thought it wasn't going to be admissible, that there was not enough time, that there were obstacles, there were non-tactical reasons that were given. So the first distinction, of course, is that it cures the silent record problem. You've actually got an unreasonable justification for the decision that counsel provided to the court, and therefore the petitioner is able to satisfy his obligation to overcome the presumption of reasonableness. But of course, in Cullen versus Pinholster, the Supreme Court has now said, even in that circumstance, you have to entertain the range of possible reasons. Griffin was a case where the court replaced the reason that counsel had given for the decision, which was an unreasonable one, with potential reasonable ones. The state respectfully submits that that case, back from 1991, I believe, or 1992, may be overruled by Cullen's instruction that you have to entertain possible reasons even when counsel gives a specific reason. But certainly Griffin is different in this case, because Griffin didn't have a silent record. You had an attorney providing the reason for why he didn't pursue this particular line of investigation.
Is a bad, an unreasonable decision any different in the end from no decision?
It's a good question. I think I would answer it as follows. An unreasonable decision, if you had proof of that, would satisfy the Syed's obligation to act. And if you have no decision, if you have evidence of no decision, if literally counsel had testified or another member of her team had testified and said, look, we didn't even think about this. We didn't make a decision here. As a consequence, that might very well create a situation where if there was record evidence that no decision was made, that would create a situation where Mr. Syed may be able to satisfy his obligation. But we don't have that here.
Is it fair to infer the obvious, and maybe not? I think Ms. McClain ultimately testified at the post-conviction hearing that she had never been contacted by Ms. Gutierrez or anyone in her firm. What do you make of that? I doubt that it was undisputed by other, that it was disputed by other testimony or
no, there's no record evidence that disputes that she was in fact
So what do you
contacted.
make of her testimony?
I think what we have here is a situation where a potential witness, one of a long list of witnesses that were contacted, wasn't contacted. But that is not the end of the inquiry. I think respondents' rule would be if in fact, on page 20 of their brief, they actually articulate this. They say, if the witness is not contacted, then the state must establish a reasonable grounds for not doing it. That, I think, is exactly the problem. That reverses the presumption of reasonableness and the burden that apply in a case like this. So Ms. McClain being contacted is certainly the first part of what they would need to establish. But they also need to establish on the record why she was not contacted.
Mr.
And that, I think, is the problem.
While we're on this topic, there's a amicus brief from the Maryland Association of Defense Counsel, and they basically say the same thing, that there should be a per se rule about contacting an alibi witness. Is Strickland in conflict with the ABA standards for criminal defense?
Yeah, I think the ABA standards have always been aspirational. It's what you should do in most cases. It does certainly establish a standard. But what they are suggesting is that you ought to do it if there's a failure to do it, that may be unreasonable if you have a justification for why they didn't do it. I don't think the ABA would ever suggest that one of its rules on a silent record would control the outcome of a Sixth Amendment inquiry, and that would be quite unusual to say that when we have a silent record, because there's a general norm that should be done, if it's not done, that would amount to a per se rule. And I think respondent is clear that that's what they wish. I think the ABA, the amicus brief is clear that that's what they wish. That is contrary to Strickland. Strickland literally debates this. The dissent by Justice Marshall says maybe we should have clear rules that explain what a counsel should do. This general standard may not be enough. And the Supreme Court's majority opinion in Strickland says, no, those mechanical rules, those per se rules, would endanger the responsibility and obligation of counsel to decide in the crucible of a particular case how to operate, what lines of investigation pursue, and which ones not. I see that my initial time is expired. I will return shortly. Thank you.
All right, thank you, counsel. Ms. Stetson.
Thank you, Your Honors. May it please the Court. My name is Kate Stetson. I represent Mr. Syed. This case doesn't involve a new per se rule. It doesn't involve an exception to an old rule. It involves the application of Strickland's objective standard to the facts in this case. Yes,
Do we have a silent record in this case? And if so, as suggested, why?
we do not have a silent record in this case. In fact, that's the theory that the state is presenting is because this is a silent record, counsel's strategic decisions have to be presumed reasonable. Every component of that is wrong. The record isn't silent, the decision wasn't strategic, and even if it wasn't reasonable. Let me tell you what is in the record, and I can do so with reference to the case that Mr. Vignaraja mentioned, Burt versus Titlow. That was a case involving a question about what an attorney had said to his client at a plea. What the court said in Burt versus Titlow is that this is not a case where where there was evidence that counsel failed to give material advice. Without evidence that counsel failed to give material advice, you couldn't find deficient performance in that case. So let's look at the record here. We have, in addition to the 2 letters from Asia McClain, identifying, of course, not just herself, but 2 other potential alibi witnesses and a camera in the library. We have, as was mentioned, the state's discovery response, and you can see this at Appendix 130, identifying the time of Hae-Min Lee's death as shortly after she left school for the day. Ms. Gutierrez got that discovery response July 10th. You heard Mr. Vignaraja say in July, in fact July 13th, you see defense notes in the record at pages 1255 and again at page 1257. Asia McClain saw him in the library at 3 o'clock. Asia's boyfriend saw him too. Library may have cameras. More defense notes. Asia and boyfriend saw him in library 2:15 to 3:15. That was 3 days after Ms. Gutierrez learned the time of death that the state was relying on. Then you have Mr. Syed's repeated requests to his client, to his lawyer, that she reach out and contact Ms. McClain.
Is there anything in the record where Mr. Syed tells the defense team, I was in the public library?
The record shows that Mr. Syed told the defense team what his general habits were that day. And I think this is an issue that we have with the state's characterization of this as an alibi. What Mr. Syed said to his defense team was, this is what I usually did. Track practice started at 4. I stayed around school until track practice.
Is that 1221?
I'm sorry?
Is that page 1221?
I believe it is, yes.
Okay.
Yes.
And is that the only place where he gives an idea of what he was doing that day?
I think it is, Your Honor, but more to the point, what you have, and Judge Getty, you referenced the ABA standards. The ABA standards, 4.1 is the relevant one here, say that even when you have a statement from your client, you still are under an obligation to investigate an alibi witness. So just to finish the record, because I think this is important, before the trial, Mr. Syed asked his lawyer, did you reach out to Ms. McClain? She lied and said nothing came of it. That's record excerpts 882. After the verdict, she said something different. Mr. Syed, upon receiving Ms. McClain's affidavit, said, did you call her? Answer, no. Did you secure the library video? Answer, no. Is there anything we can do about it now? Answer, no. That's in the Court of Special Appeals opinion. And then you have, of course, the unchallenged finding by the circuit court that Asia McClain was never contacted, and the state has acceded to that again today. That is not a silent record. That is exactly the sort of record that Burt versus Titlow was talking about. What you're left with
Did the video ever surface?
No, the video never surfaced because it was never sought, Your Honor. At the point at which this came to light, of course, this was in the post-conviction proceedings in 2012. But the issue, I think, with resting on this idea of a silent record is because of something that I mentioned when I first stood up that you didn't hear Mr. Vignaraja say, because it's not in his briefs, not once, which is the standard under Strickland is an objective standard, is an objective standard of reasonableness. Every single Strickland case that the state cites contains that phrase. And because it's an objective standard of reasonableness, you don't need to look to counsel's subjective explanations for why she did what she did. And this is where the state's arguments kind of turn in on themselves, because on the one hand, they want to make a lot of the fact that Ms. Gutierrez isn't here to explain herself, because that is the sole thing that's not in the record. What was her explanation? That happens to be the one thing that we don't need under Strickland, because what Strickland tells you is don't look at counsel's explanations. You heard the state say this again today. You can look at counsel's perspective at the time of the investigation, and that phrase is important. It's from Rumpilla, and that's the time that we're talking about here. Look at counsel's perspective at the time of the investigation and ask yourself, was it reasonable, given that you knew this witness could identify another alibi witness and had mentioned cameras, and that it covered the time of death that you knew the state was focusing on, was it reasonable not to pick up the phone and make a call?
So are you saying that you are not advocating for a per se rule that a defense attorney must contact any alibi witness offered by?
Not at all, Your Honor. In fact, this is one of the things that Strickland emphasizes as well. Strickland says on multiple occasions, you apply these general tests, this objective reasonableness test, to the facts and circumstances of the case before you. So our position here isn't that there's a per se rule that every time there's an alibi witness, she must be contacted. It's that in this case, where you have an alibi witness who supplies the phone number, who identifies another alibi witness or two, and some library footage, and counsel requests that the client requests that counsel follow up with that alibi witness, and the alibi witness was willing to come forward and testify, yes, then you have a Strickland problem. And that's what the Court of Special Appeals found. And I want to emphasize that this had nothing to do with counsel's unavailability. If you look at the Court of Special Appeals' decision, and this is at Record Excerpts 107 to 108, the Court of Special Appeals acknowledges that Ms. Gutierrez is not here anymore. But then it goes on to say this, even without trial counsel's explanation for her failure to investigate the claim, we must still assess trial counsel's performance under the objective standard of a reasonably competent attorney acting under prevailing norms. The Court also paid close attention to what Mr. Vidnaraja mentioned this morning, the presumption of reasonableness. That occurs throughout the decision. But a presumption, like any other presumption, can be overcome. And what the Circuit Court and the Court of Special Appeals concluded here was that the presumption of reasonableness was overborne. In fact, the Court of Special Appeals indulged all of the state's potential rationales for why Ms. Gutierrez might not have contacted this alibi witness when she first surfaced during the investigatory stage, and found all of those lacking to the point where the Court of Special Appeals concluded neither a review of the record nor of the state's arguments provides a reasonable basis to justify the failure to call, and I mean to pick up the telephone and call, Asia McClain. This fell below the objective standard of a reasonably competent attorney acting under prevailing norms, taking into consideration all of the circumstances and with a strong presumption of reasonable professional assistance.
Now,
that is a simple...
Moving to prejudice for a moment, how do we, as I recall, the Circuit Court determined that there was no prejudice.
The Circuit Court did, yes, Judge.
And the Circuit Court is on the scene, gets the rhythm of the trial, language that we've heard many times before. How do we decide, and under what standard of review do we determine whether or not there was prejudice?
So the standard of review is de novo, because any Strickland question presents mixed questions of law and fact. So with respect to, for example, the factual finding that the state doesn't contest that Asia McClain was never called, that's a clear error review. But when you look at deficiency and prejudice, that's a de novo standard of review.
Well, now, mixed law and fact is not 100% de novo.
I'm sorry?
As I understand the standard of review, mixed law and fact is not necessarily completely de novo review.
Well,
it doesn't become all law.
Right, but it's because of those, if there are underlying questions of fact, like the one that I mentioned, Asia McClain was never contacted, that's clear error. But what the courts consistently have held is that when you look at the Strickland standards overall, you are making a legal finding. Was this deficient? Was it reasonable? Was it prejudicial? So the Court of Special Appeals undertook a de novo review. The reason that it disagreed with the Circuit Court's decision is because the Circuit Court had based its prejudice finding on the notion that the crux of the murder case had to do with the burial. But what the Court of Special Appeals explained, of course, was that the crux of a murder case is the murder. And where you have an alibi that covers the time of the murder, you can't look to subsequent events to figure out whether or not that alibi would have assisted. In fact, if you look at the Connecticut Supreme Court's decision in the Staple case, which came out in May of this year, you will find, among other things, a thorough recitation of the many dozens of cases where failure to call an alibi witness has been deemed deficient. And then you'll find a phrase that says, we have not found a single case where an independent, non-cumulative alibi witness was found not to be prejudicial. That, I think, speaks volumes. The reason that an alibi witness, of course, by its nature, is important is for the reason that the expert below gave, Mr. Irwin. An alibi witness is the best defense you can have. So, of course, you're going to have a remarkable unanimity in the cases that find that where you have an independent, non-cumulative, of course this was non-cumulative, alibi witness, of course it's going to be prejudicial. And in fact, the state's brief, if you examine it, doesn't include a case cite to the idea that this could be other than prejudicial because it was deficient performance.
Is it possible, and not possible, but in this particular case, is it conceivable that defense counsel determined that she had a better alibi witness than McClain?
I think it's a good question, Judge Green, for this reason. The reasons that the state has offered for why counsel might have thought that she had a better alibi elsewhere, all of them go to trial strategy. And you heard counsel mention the Kimmelman case. That's actually very helpful to us as well. Because what Kimmelman says is, when a lawyer makes a significant error at the discovery stage, you can't look to the later trial and how that strategy played out to determine whether that error was or was not deficient. You look, of course, to the investigatory stage. You look to the questions at the time. And if you look at the reasons that the state is offering, pages 36 through 41 of its brief, all of them have to do with Ms. Gutierrez's ultimate trial strategy. Did this alibi conflict with the statements Mr. Syed made about his general habit? First of all, that doesn't conflict at all. And Ms. Gutierrez never offered an alibi for the time of the crime, only that he was at track practice, which started at 4 p.m. So there wasn't anything inconsistent to begin with. All of the other possible strategic reasons that the state has floated here, all of them have to do with trial strategy, and I can walk through them. So we've already talked about the first one, alibi inconsistent with what Mr. Syed told the police. First of all, it wasn't inconsistent. Second of all, the ABA standards require her to investigate anyway. Third of all, that goes to her ultimate trial strategy, what she chose to put on. And what she did not put on was an alibi.
It wasn't consistent to the extent that he omitted telling the detective that he had ever been to the Woodlawn Public Library.
It was inconsistent only to that extent. But remember, this was not part of his regular routine, and he was only there perhaps for a short period of time. So I don't think that when she is making a decision in July of 1999, months before she goes to trial, about whether to pick up the phone and call an alibi witness who she knows is suggesting that she and two other people and a camera all can attest to Mr. Syed's whereabouts at the time of the crime, I don't think there's anything inconsistent between saying that and I usually went to track practice after school. State's second reason was unnecessary.
It was inconsistent to the extent that he didn't tell the police about the library, and there were already, as I understand it, 2 inconsistencies in what he had given the detective about whether he drove to school or was relying on a ride.
Judge Watts, I think at bottom it gets back to the question that I think Judge Adkins asked my brother counsel, which was, does any of that obviate the need for her to pick up the phone and call Asia McClain? Now, it may have been, and this is why all of the state's arguments go to trial strategy, maybe there was some reason at trial, the way it played out, for her to advance the case that she did. But you can't make a reasoned decision about what trial strategy you're going to engage in without calling an alibi witness and asking whether that testimony is going to help your case, even if it is inconsistent. That's what the ABA standards say. You have an obligation to follow avenues of investigation, even if your client, your own client, tells you something different. The reason that the amicus brief is so important, I think, is because this isn't just a collection of defense counsel. This is the Maryland public defender telling this court that this is a baseline obligation of reasonable performance by defense counsel. And of course, that's the Strickland standard. Was this reasonable under prevailing professional norms? Was this objectively reasonable?
Here there were 2 letters from the witness, the potential witness. Would that undermine the advice in the ABA standard or the obligation under the standard of objective reasonableness to contact the witness where we have 2 letters summarizing what she's going to say?
No, Judge Watts, I don't think it does for 2 reasons. The first is, anytime you have an alibi witness, you're of course going to know what that alibi witness is likely to say. That's the nature of an alibi. But second, remember something that I've emphasized. Those letters didn't just identify her as being in the library. They identified her and her boyfriend's friend, and a camera. So even if Ms. Gutierrez thought, well, I pretty much know what she's going to say. She's going to say that she was there right at the time the murder occurred. She needed to follow up and ask the question, who was with you? Can they come? What was the camera? And to follow up and get the library camera, which Mr. Syed repeatedly asked his lawyer to do.
Now, was the camera mentioned in her defense notes?
It was indeed, yes. At page 1255 of the record excerpt, Asia McClain saw him in the library at 3 o'clock. Asia's boyfriend saw him too. Library may have cameras. So you have not just the letter saying, I called the library and they say there's a security camera. You have the defense notes. And remember, this was 3 days after Ms. Gutierrez was put on notice about the time of death that the state was identifying. 3 days later, she writes this note, Asia McClain, 3 o'clock, library may have cameras. So this is not a silent record. This was not a strategic decision. But in the end, none of that matters because this objective standard is what controls here. And what the Court of Special Appeals found in its thorough decision, repeatedly citing Strickland, repeatedly invoking the objective standard, was that this was objectively unreasonable.
Do we have any testimony that she never checked to see if there was a security camera?
We do. We have testimony from Mr. Syed at the post-conviction hearing. And you can find this. This is actually quoted in the Court of Special Appeals' opinion. Mr. Syed, after he receives Ms. McClain's affidavit in early 2000, Mr. Syed asks his lawyer, did you call her? The lawyer said no. Did you get the library camera? The lawyer said no. Is there anything we can do about this? The lawyer said no. We have to focus on the appeal. So that was in the record. And of course it was in the record that he repeatedly asked her to get the library camera. And it is in the record that she lied to him before trial and told him that nothing had come of it. So for all of the reasons that I've been saying, I think what this boils down to, the cleanest way through this, is the simple objective test of Strickland, which is, was this performance on these facts, when you have an alibi witness identifying 2 others and a camera for the time of death, giving a phone number, all of those reasons, was it objectively unreasonable for Ms. Gutierrez not just to pick up the phone and call? And the answer to that is quite plainly yes. If I could speak briefly to the cross petition, this is on the waiver issue. I think the problem, the fundamental problem with this is that the Court of Special Appeals essentially relabeled a fundamental right as something other than a fundamental right. in order to find waiver. You can find this at Joint Record Excerpts 71 and 73. What it says is, because the cell tower claim was an ineffective assistance claim, and there was a previous independent ineffective assistance claim that had been raised, that cell tower ineffective assistance claim is premised on a non-fundamental right. Now, that simply can't be so. An ineffective assistance claim, the Sixth Amendment right to counsel, under Kimmelman, is beyond question, that's a quote, a fundamental right. And that's why, if you look at the state's responsive brief on this, the state really doesn't latch onto the Court of Special Appeals as relabeling in that sense. What it says is, well, the Maryland legislature has passed laws restricting the filing of petitions to one. That's absolutely right. The gatekeeping function here is not to relabel a fundamental right as something other than a fundamental right. It's to look to exactly what the circuit court did here, which was first find that there were interests of justice that warranted the reopening of the petition. This wasn't a successive petition; it was a reopening. And the second was that there was a presumption, of course, that attaches to every, even a fundamental right, that there was a knowing and intelligent waiver. And the trial court here found that that presumption was overborne. Those are the gatekeeping functions that are in place, that were employed during this case, and that are in place in order to guard against what the state is suggesting might be a flood of successive petitions involving ineffective assistance. A trial court doesn't even need to give reasons why it denies reopening. That's the Gray case from this court. All the trial court needs to say is denied. So it is not a burden on trial courts if they are presented with multiple successive, frivolous, ineffective assistance petitions to simply deny them from going forward. That's the trial court's role. What is not appropriate is for the court to relabel a fundamental right as a non-fundamental right. Curtis is very clear, as is the Supreme Court, that the right to counsel is a fundamental right. This cell tower claim was based on an ineffective assistance claim, right to counsel, fundamental right. Under Curtis, it should have been entertained. If there are no questions on that, I'll save my time.
All right, thank you, Ms. Stetson. Mr. Bignoraja? And you reserve 15 minutes.
If I may, Your Honor, I want to correct a couple of statements by respondent. The first issue that I want to take with Ms. Stetson is whether or not the record is silent. The record is not silent on whether or not Ms. McClain was contacted. The state agrees with that. The record is silent on the critical question of why. On that particular question of why Ms. Gutierrez decided, as Strickland put it, to conclude that one investigative path was unnecessary, the record is silent. The Court of Appeals at E107 says, because of trial counsel's death, there is no record of why trial counsel decided not to make any attempt to contact McClain and investigate the importance or not of her testimony to Syed's defense. In Judge Grave's dissent on page 147, Judge Grave points out that we don't know the reasons, whether they are the reasons that the state proffers, the reasons that Judge Grave proffers, or some other reason. We don't know why she didn't make that decision. And in fact, defense counsel acknowledges this. On page 25 of their brief, defense counsel writes, this record in this case reveals no contemporaneous tactical consideration that could have justified trial counsel's failure to even contact McClain. Later in the page, because there is no evidence of any contemporaneous judgment that trial counsel made in reaching this decision, only a resounding lack of follow-through, there is no tactical decision meriting a presumption of reasonableness. What they're suggesting is that if we don't have evidence of a tactical decision, the presumption does not apply. But that's exactly backwards. Mr. Syed's obligation is to establish the reason as unreasonable. That is how you overcome the presumption of reasonableness. And in fact, Burt v. Titlow and a number of other cases say precisely this. I'd like to just read from page 2223 of Burt versus Titlow, which I think makes this crystal clear. Even more troubling is the Sixth Circuit's conclusion that Tocco was ineffective because the record in this case contains no evidence that he gave constitutionally adequate advice. We have said that counsel should be strongly presumed to have rendered adequate assistance and make all significant decisions in the exercise of reasonable professional judgment. And the burden to show that counsel's performance was deficient rests squarely on the defendant. The Sixth Circuit turned that presumption of effectiveness on its head. It should go without saying that the absence of evidence cannot overcome the strong presumption that counsel's conduct fell within the wide range of reasonable professional assistance. Record evidence that Ms. McClain was not contacted is not complete the gap. The gap is as to why Ms. Gutierrez did not to contact Ms. McClain. And, Your Honor, respectfully, that is precisely the cases that we have cited where this has been found. I don't know what level of research the court in Skakel did. In Skakel, of course, a case that's cited by the amicus, there is a reason provided by counsel for why a particular witness was not pursued, and that was considered unreasonable. But in Broadnex versus State, an Alabama case, there was no investigation of putative alibi witnesses. The court nevertheless found that this was not a violation of the Sixth Amendment. In Commonwealth versus Rainey, also cited by the State, 928A2D 215, Pennsylvania 2007, this was considered not ineffective where an alibi testimony was inconsistent with defense strategy. In Weeks versus Senkowski, 275 Federal Sup 2D 331, at 3-page 341, the Eastern District of New York concludes that it's not ineffective to decline to contact alibis who have some fatal flaw. Now, Ms. Stetson's response, and I could go on and provide additional cases, is that the right is triggered when it's a dispassionate alibi witness where you have enough information, it's non-cumulative, and if you create such a canon, you can carve out a relatively modest-seeming per se rule. But it's still a per se rule. And it means that counsel has to make all kinds of determinations of how close they would be to that per se rule or not, and that's not what Strickland contemplates.
Mr. Vignarajah, did the proposed McClain alibi have flaws or fatal flaws?
It did. And we've identified ones that would be consistent with exactly the reasons that Strickland says counsel may go in a different direction. One of them is the inconsistency with what Mr. Syed said. At 1221 and 1229, these are both places Mr. Syed in the joint extract. Mr. Syed is given an opportunity to lay out where he could have been. He does not mention the public library. That is an inconsistency that would have been on top of already inconsistencies that were created that not only did Ms. Gutierrez was aware of, she in her notes recognizes this, the state exploited those inconsistencies. This would have been an additional one. But in addition,
were there indications of untrustworthiness or issues with the witness's credibility in the two letters?
There were. It's important to remember that Judge Welch, when he first examined just the letters, which is exactly what Ms. Gutierrez would have had, said a reasonable attorney could have concluded and interpreted these letters as an offer to lie. There were specific sentences that said, if you are innocent, I can help account for your unaccounted, unwitnessed time. Maybe if I contact you first, you'll get a head start over the police. Those are the kinds of warning signs that a seasoned attorney could say, I don't know that I want to touch that. There was, of course, additional information that was available to Ms. Gutierrez in the detective notes that there was on April 9th, 1999, Mr. Syed's best friend, Jawan Gordon, gave a statement to police that Syed had contacted him and that Syed had sent a letter to a girl named Asia to type up, but she got that letter, but she got the address wrong. Those are the kinds of things that are warning, and I should emphasize that there's a particular challenge with this time right after school. Ms. Stetson says that was never accounted for. In fact, she acknowledges, and I think this is an important acknowledgement, that this would have been a deviation. She said this wasn't usual. The usual pattern was school, track, mosque. The suggestion that Ms. Gutierrez was required by the Constitution to pursue a deviation from your habit on the very day that the person who you are accused of killing goes missing is an extraordinary leap to require that. But moreover, Ms. Gutierrez knew what Mr. Syed had told her he usually does between school and track practice. At 12:29, there is a October 12th memorandum where Mr. Syed explains to his counsel's team that between school and track practice, he would routinely, when school was in session, go to the Best Buy parking lot to have a private encounter with Hae-Min Lee. Ms. Gutierrez was aware of that. To suggest that it was a wise strategy to focus on a window of time when her own client had told her, where I usually am in that window of time is at the location I'm accused of killing the person I am accused of killing. That also is a terrible risk, because if people had started focusing on that 2:15 to 3:15 hour, that is exactly going to place Mr. Syed at the location with the victim. In fact, in that same memorandum, the clerk asks, who else knows about this? And Mr. Syed forthrightly explains that several witnesses would be aware of this relationship. One of them was a grand jury witness. Another was a witness that Ms. Gutierrez could have assumed that that the police would contact. So that, too, is a risk. Judge Atkins, you had asked about the video being pursued, and I want to just sort of clarify a couple of things with this respect. First, on excerpt page 1217, there's a billing summary from the first 10 days of the investigation. This is weeks before Ms. Gutierrez was even involved. And there it chronicles the steps that the initial private investigator took within days of Mr. Syed's arrest. One of the first things they did was to go to the Baltimore County Public Library and talk with the security officer that was there, a Walken House officer, Stephen Mills. That suggests that they did pursue the public library and what might have been collected from there. Moreover, during the post-conviction hearing, two individuals testified who had worked there, the security officer as well as one of the managers. Both of them, the manager indicated, I should clarify, that the video would have been overrun within days of it being done. This is not one that they kept for months and months, and you have to recall that the murder happened a long time before the body was recovered, which was still weeks before Mr. Syed was arrested. So there is an indication that that was pursued somewhat, and in Mr. Syed's testimony to the post-conviction court, he does say that certain things weren't done, but what he says is that Ms. Gutierrez told him that she had looked into it and nothing came of that. I'm not suggesting that that supports that Ms. McClain was contacted. I am suggesting that there is evidence that the general form of this alibi was known to Ms. Gutierrez and that it was somewhat pursued. Not by contacting Ms. McClain, but an alibi, of course, is not just a person, it's a place and a time. They certainly looked at that window of time, and what they heard from Mr. Syed was that he was typically at the Best Buy parking lot with Hae-Min Lee. The last thing I want to do, Your Honor, is talk about this notion of a per se rule. Be clear, in their briefing, that is precisely what they asked for. On page 20 and 28 of their brief, they suggest that the default presumption should change if they are able to establish that the witness was not contacted. And then on page 28, I think in a very revealing passage, they distinguished a failure to contact an alibi witness from a whole range of other decisions, whether to cross-examine, whether to pursue one alibi strategy instead of another. And with respect to all these decisions, they say that there are two sides. It could be reasonable, it could be unreasonable. But with respect to failing to contact Ms. McClain, it is always unreasonable. There's only one side, to use their language. That is tantamount to a per se rule. And whether we cabin that per se rule with conditions about how long or how accurate or how potent, it still is a per se rule.
Why wouldn't it be equally fair to characterize Ms. Stetson's position as, under the circumstances of this case, it makes no sense at all that Ms. Gutierrez did not at least pick up the phone and make a phone call?
It's a fair question. I think the reason why that's not enough is because of the problem with the silent record. I think the reason why Ms. Stetson has to ultimately adopt a view that you have to contact the person in this particular case, and even though the record is silent, you have to do it and it's a deficient performance otherwise, is because of the silent record. Without a per se rule, you can't escape Burt versus Titlow and all these other cases that do this. And I want to just read a couple of examples of the language and how crystal clear courts have been. I read you in Broadnex, it says it is extremely difficult to prove a claim of ineffective assistance of counsel without questioning counsel about the specific claim. In Williams, the court in the 11th Circuit says, where the record is incomplete or unclear about counsel's actions, we will presume that he did what he should have done and he exercised reasonable professional judgment, noting that the district court correctly refused to turn that presumption on its head by giving William the benefit of the doubt. In Jones, the court said, when the record is silent on the motivations underlying counsel's tactical decisions, the appellant usually cannot overcome the strong presumption that counsel's conduct was unreasonable. And in Dunway, the court says, if the record is silent as to the reasoning behind counsel's actions, the presumption of effectiveness is sufficient to deny relief on an ineffective assistance of counsel claim. There are a number of cases that adopt exactly this reasoning. We have not found a case that on a silent record deficient performance has been found. And then we reach, of course, the question of prejudice. The post-conviction court originally concluded that this was not prejudicial. They made a judgment based on their assessment of what was important and what was significant. I do believe that that is owed some measure of deference. It is not clear error review or anything like that, but it is a mixed question of law and fact. And Judge Welch was aware of all of the evidence that was presented, evidence of motive, evidence of preparation, evidence of the accomplice saying that he told me he was going to do it beforehand, he asked me to help, he called me the day before, he gave me his car and cell phone that day, he showed me the body and I helped bury it. Corroborating witnesses that were disinterested witnesses as well, that said that I saw those two individuals together or I talked to those two individuals together on 3 separate occasions at 3 separate places on the evening of the murder. Mr. Wilds led the police to the car, and 3 witnesses said that Mr. Wilds and Mr. Syed were together on the afternoon and evening of January 13th. Nisha Tanna said that she talked to both of them. Jennifer Pusateri said that she saw them later. And with all of this, we believe that this is a terrible case to depart from settled precedent. Thank you, Your Honor.
Thank you, counsel. Ms. Stetson, you reserve 5 minutes.
Thank you, Your Honor. I'd like to point out a few things that Mr. Vignarajah did not say. The first is he has no response to our observation in the Court of Special Appeals' repeated observation that this is an objective test. You do not need counsel's explanation about why she did or did not do what she did. That's why the Court of Special Appeals, immediately after the passage that Mr. Vignarajah read to you, went on in the passage that I read to you to say, regardless, it's our obligation to conduct an objective review, and we find, and later in the opinion, we find that this performance was objectively unreasonable. You also did not hear Mr. Vignarajah acknowledge that a presumption is just that. It is a presumption. It can be overborne. And it was overborne in this case for all of the reasons that we have discussed. You had a request to pursue an alibi witness. You had an alibi witness who was available through a local telephone call. You had her identifying 2 other witnesses and a camera. And you had a failure to make that telephone call. Even in the cases that Mr. Vignarajah cites, the example, for example, of a corroborating witness that Mr. Vignarajah ended on, the Montgomery versus Peterson case out of the 6th Circuit involves exactly these circumstances. A star corroborating witness who was alleged to have committed the crime with the defendant, telephone records, additional witnesses attesting to his whereabouts, and all of that was found to be overborne because trial counsel in that case had failed to follow up with an alibi witness who could testify to the defendant being somewhere else at exactly the time that the crime was being committed. The last thing I think I would say is, remember that this is not just about the Asia McClain letter. And even if counsel thought that the Asia McClain letters were on their face somewhat deficient, counsel had an obligation to pursue that witness and the 2 other witnesses that she mentioned and the camera. You can find multiple cases. Montgomery is another example where the counsel in that case said, I didn't follow through with that alibi witness because I thought that she was lying. And what the Court of Appeals have said repeatedly is, that doesn't matter. You make the phone call. This is not a per se rule that we are asking for. This is a ruling in this case This is why we said in our opposition to the cert petition in this case, this is uniquely unsuitable for some per se rule. Strickland does not ask for per se rules. Strickland demands that you look at the circumstances of this case and decide whether the facts in front of you, not the facts that were retried just now by Mr. Vignarajah, but the failure to identify and pursue an alibi witness who covers the time of the crime and who could have led to 2 other witnesses and a camera if timely pursued, whether that was objectively unreasonable. The reasons that she might have offered don't matter. This was objectively unreasonable, and that is exactly what the Court of Special Appeals found. If there are no other questions.
Thank you, Ms. Stetson, Mr. Vignarajah. The case is concluded. The Court will take a brief recess.